Hello, everyone. Welcome back to our season three. Today, it is an absolute privilege to host our guest today, a jurist whose distinguished career spans over 4 decades of profound legal service and judicial reform. We are joined by Justice Hemant Gupta, former judge of the Supreme Court of India. Justice Gupta comes from a revered legal lineage, with both his grandfather and father having served the law, the latter as the Chief Justice of the Punjab and Haryana High Court. After enrolling as an advocate in 1980, Justice Gupta built a formidable reputation arguing complex civil, constitutional, and labor matters, leading to his appointment as the Additional Advocate General of Punjab in 1997. His judicial career took flight in 2002 when he was elevated as a judge of the Punjab and Haryana High Court. Notably, during his decade long tenure on the court's computer committee, he became a pioneer for judicial modernization. He spearheaded the digital transformation of the court, introducing landmark tech frameworks like e-filing, e-diaries, digitized case management, and automated centralized copy agencies. Reforms that fundamentally shaped the efficiency of the modern Indian courtroom. Justice Gupta went on to serve with distinction as the acting Chief Justice of the Patna High Court and later as the Chief Justice of Madhya Pradesh High Court before his elevation to the apex court of the nation in November 2018. During his 4 year tenure at the Supreme Court, he was known for his remarkable efficiency and razor sharp clarity, authoring a vast number of critical rulings spanning constitutional validity, land acquisition, and civil liberties. Following his retirement from active judicial service in late 2022, he took on the mantle of leadership as the chairperson of the India International Arbitration Center, where he continues to lead the charge in shifting India's legal landscape towards institutional dispute resolution and global credibility. We are extremely delighted to welcome you, sir.
Thank you. Thank you, Ritu. Thank you very much.
So, sir, to start with, you spent over 2 decades as a practicing lawyer before becoming a judge. What is the hardest habit as an advocate you had to break when you transitioned from fighting a case to deciding one?
It was a difficult proposition. As a lawyer, everybody was a friend. We had spent time together. Sometimes you call lawyers by their nickname. And
Yes.
suddenly in court, you call Mr. Pavan so and so. It was odd for me to say and for them to hear also. But it's not a difficult thing. One gets used to it. Actually, before I became judge, I met one of the senior judges of Punjab and Haryana High Court in connection with something in his chamber. I told him that I'm feeling little afraid of sitting alone in front of the lawyers. As a judge, you sit on the dais. Everybody is facing you. He says, "Don't worry, grass is greener on both sides." That made me a little comfortable, and that was one difficulty about the names. Sometimes I will not recollect names. I remember I continued to call one lawyer by his nickname, and which was not really a nickname, but popular name. Yeah. But he corrected me to say that I'm not so and so, I'm so and so. But otherwise, once you have experience of 2 decades, of more than 2 decades, you gradually shift to the new challenges. It's not difficult. Actually, the work is the same. It's deciding cases. Earlier, it was arguing cases. Now, deciding cases. The issue remains the same. How to project your point of view and how to articulate your point of view in judgment. It was not very difficult, I would say so.
Right, sir. So in India, judges are frequently transferred to different states. In your experience, how does this policy affect the judge? And did you notice any difference in the practice styles of the courts where you practiced or presided?
Yes. No, there was in 94, 95, there was a policy that 1/3 judges would be from outside the court. But when my consent was sought for appointment, the Chief Justice told me that policy is no longer there. You are going to be here in Punjab and Haryana. But exceptions apart, some judges are transferred for ABC reason. I will not go into that. But the fact remains, it's harsh on the judge. Uh,
Mm.
I remember a particular judge from Punjab was transferred to Chennai. He could not adjust in the environment because they said the way the lawyers stand, it is a
Mm.
U-shaped court, and we are not used to. We see in front everybody. That is not the practice in many other courts. But it was a big challenge, change for me when I went to Patna. There was a concept of mentioning before the court.
Okay.
And mentioning means like in mentioning before the Supreme Court. Uh,
Yeah.
the lawyers make request either to take up their cases or not to take up
Mm.
their cases.
Yes.
So it was a big surprise for me because we had not seen that kind of system in Punjab. But suddenly I discussed with my colleagues or registrar judicial that should we change it. Then
Mm.
I realized that I'm the only one outside from that court.
Okay.
Everybody, the lawyers and judges they have grown with the particular system. Why
Mm.
change? It's better to adjust to the new environment. I adjusted
Mm.
very well. Then things became easy. It's a mind, which has to be adjusted. Like I will give you example in Punjab. One judge, Chief Justice, came from Chennai. In Chennai, there must be a practice of having a bell to start as if the court is starting or course is
Oh.
breaking or something. It was not really, it was a new thing for us. And he became quite a controversial judge. Uh, the bar and the bench, both were not with him. So that creates a difficulty because you can't introduce new systems in the new court.
Mm. Right.
It's better to change according to uh, the working style of that court. I remember that particular judge, you know, in all systems, even in Supreme Court, the junior judge sits on the left of the judge.
Yes.
Uh, but he insisted, no, junior judge should sit on the right because that is the practice in Chennai.
Can I bend?
Um, but the very first case on the first day itself, there was not very pleasant encounter. But people get used to it. It's better to change to the new environment. Because you are the
Right.
only one from the different environment. Better to change yourself.
Rightly said, sir. So the Supreme Court, as we all know, faces an overwhelming volume of daily appeals. How did you manage to read, hear, and decide large volume of cases listed every day?
In Supreme Court, we had the facility of law clerks.
Yeah.
There were three at that time. Now probably there are four. They will prepare notes. But my habit was not to depend upon the notes prepared by the law clerk. I would like to read the file myself. But then you develop a habit that if it's a fresh matter, you devote little more time. Is after notice matter, you just glance through it because both sides are represented in those matters. So you can be rest assured that if there is some mistake on the part of the petitioner lawyer, the respondent lawyer will correct it. So
Mm.
this is a mechanism which you know by practice. That's how the thing will move. It's a volume of work is there, but you because the training of many years is there. How to
Right.
glance through the file, read file. No, I will not read the whole judgment. The only thing is, uh, you know, some or the other, my I will go to the point which is the debatable issue.
Mm.
This is, I would say, only the habit or the practice which you develop with the passage of time.
Yes, sir. I mean, sounds very easy, but we all know how difficult that is. So maintaining
And,
absolute, sorry, sir, yes.
because you are a youngster,
Mhm.
you have not seen many files, many records. By the time I came to the Supreme Court, I had an experience of more than 35 years.
Yes.
So, that experience was, and I was not, I would say, very busy lawyer, but I was reasonably busy lawyer. And as a busy lawyer, and did a lot of work as a judge. So all kind of litigation I had handled. So it became easy for me to glance through the facts.
Right, sir.
Yeah.
And so, we usually hear that, maintaining absolute neutrality and independence is the hallmark of a judge. So, how difficult is it, in your opinion, to maintain complete intellectual isolation when a case or even the court itself becomes a center of heavy media and political scrutiny?
You know, the impartiality is hallmark, as you have rightly said, and it doesn't come. It's not interfered with, by any person. It's all depends upon you that how much you are willing to give in.
Mm.
Sometimes the judges are overawed by the presence of the big and famous lawyers.
Mm.
Sometimes it's just indifferent. I don't know what is the reason, but I never faced difficulty throughout my career, either in the High Court or uh, in the Supreme Court. I just point out one thing. I was a young lawyer dealing with a criminal case. I was for the respondent. The advocate for the petitioner for the other side was Mr. Kapil Sibal's father, Mr. Hiral Sibal. He was a renowned lawyer, well-known lawyer, and
Yeah.
doyen of Indian of bar. The lawyer assisting him asked me, "You will be arguing yourself, or you will be engaging somebody else?" "Well, I will
Okay.
argue myself." So this is how it really doesn't matter whomsoever you
Mm.
are opposing, or you have to have confidence in you. You will
Mm.
sail
Well said. Even
through.
today, we also get so scared when a CBC is appearing, opposite us. But yes, you're right. Confidence is what matters. So with
Confidence is matter. Ultimately, the facts of the case are supporting you or whatever. If you know the facts, you can counter any lawyer. Ultimately, he has to argue on the facts only.
right, so with growing concerns over pendency proposals such as a day and night courts, shift-based functioning, limited vacations, and year-round court operations are frequently discussed. Which of these reforms do you believe holds the greatest potential for improving access to justice and timely case disposal in India?
No, it's a difficult question. Access to justice is a belief of the people in the system.
Mm.
That's why people are coming to court. Uh, that is one way of looking at it. But the practical difficulty is if they don't get redressal of their grievances at the
Mm.
first instance or at the earliest instance, it
Mm.
they feel frustrated.
Yes.
Like, but I would say it's a self-discipline of the courts, which is more
Okay.
important. Like in the High Court, there is power under Section 482. There is a
Mm.
power of a revision in a criminal matter. The revision is concurrent with the session judge and with the High Court. If you want to exercise jurisdiction, you can enlarge that jurisdiction. You can start interfering revisions in all cases. But if
Mm.
there is a hierarchy, there is a session court who is compelled to decide that revisional matter. You should delegate the parties or relegate the parties to that jurisdiction. But
Mm.
now the difficulty which we read that from the newspapers, that everybody wants to come to the Supreme Court for
Yes.
everything. Supreme Court is not the answer for everything. There is a complete hierarchy. The high courts are there, district judges are there, the sub judges are there. Complete hierarchy is there. Uh, that temptation to interfere in the at that level
Yes.
um, should not be there. But I understand from the newspaper reports. My information is based on newspaper reports that courts are now saying that go to the high court. Why don't you go to the high
Yeah.
court? High courts are also competent to exercise jurisdiction. No, if the high court exercises jurisdiction, it becomes easier for the Supreme Court to decide it because there is one view is already taken.
Yes.
Then you have to either say good, bad, or indifferent. You don't have to take a fresh view in the matter, and that
Yeah.
is the also the purpose of the hierarchy.
Yes.
You
We all
know,
have to respect the territorial jurisdiction. True.
territorial jurisdiction, and actually, as a student of law, we were always believed in this. The writ jurisdiction of the High Court is wider than that of the Supreme Court under Article 32. But the lawyers find it very easy to approach Supreme Court. One, it gives a finality at the highest level. And obviously, the topmost brains are there.
Yes.
The, the appreciation is different, is better.
Mhm.
But that doesn't mean that you bypass the normal hierarchy of justice.
Right, sir. So, as you mentioned, as we talked about High Court and Supreme Court, Delhi district courts have largely adopted a courtroom-based hybrid hearing model, where individual courts maintain dedicated video conferencing facilities and hearing links. However, in many district courts across India, lawyers and litigants still have to rely on a common video conferencing room or a shared facility that is used only upon request. What, in your opinion or view, explains this disparity in digital infrastructure between jurisdictions, and what steps are necessary to ensure that every courtroom in India is equipped for seamless hybrid hearing?
Now, Delhi is privileged in a sense that there is no dearth of money. The funding is quite liberal. I can give you my example of Madhya Pradesh. There was always a complaint that the criminal cases take a lot of time to decide.
Mm.
Then what was the issue I discussed with them? It says the doctors don't appear and the investigating officer doesn't appear. Because Madhya Pradesh is a
Okay.
big state. From one corner
Mm.
to the other state, sometimes it takes 10 hours to travel. So I decided, in consultation with my colleagues and the state government, will provide video conferencing facility to all session trials. And Madhya
Okay.
Pradesh, a big state, it came out to be 1,000 video conferencing units, 800 for the judicial officers. We said that police stations will be connected, the civil hospital should be connected because the doctor if he has to search for video conferencing facility, that will not
Mm.
make any sense. And with the cooperation of the state government, and of course we had some diversification of funds, we could provide video conferencing facility in all session courts because
Okay.
they are the serious offenses. Magistrates courts are still, we were struggling at that time. But we
Mm.
thought that firstly, we should have actually video conferencing facility in the session courts. So that's possible. It's all depends upon money.
Yeah.
If the money is available, you can do it. And it's actually same thing we did in Punjab.
Okay.
Punjab also, the doctors, like there is a famous institute, PGI, which is at par with AIMS, is a counterpart of AIMS
Okay.
in Delhi. The
Okay.
doctors go back to their parent station. Some are there. It's a post-graduation institute. Many doctors come from all over the country. Then that doctor can't appear as a witness because he has conducted some this injury statement or hospital serious surgeries, medical statements or something. So we provided video conferencing facility to PGI. There was a one telehearing room was created in PGI, and to the doctors anywhere else they can appear. We said that because at that time there were not many video conferencing facility. Says you can go to the district court of that particular district where there is a video
Yeah.
conferencing facility, where you can appear as a witness. Because the doctor, and I remember in Chandigarh, one doctor had to travel 10 hours to go to for a statement in Himachal Pradesh, because Himachal Pradesh patients were very commonly there. With patients from Jammu and Kashmir, patients from Uttarakhand. So
Mm.
the doctor had to go everywhere. So that became easy for the doctors because the doctor is visiting at the cost of other patients, and because the traveling time, and they had actually at that time PA only one Maruti uh, vehicle,
Okay.
and
Yeah.
it became difficult. That vehicle is not available. How do the doctor go? Otherwise, the burden will come on the patient or the relatives that they have to arrange for. So it was difficult, but
Mm.
actually at that time it was great initiative which was taken by me. Of
Yes, sir.
course, not by, but with the
No, sir, we've all
corporate.
heard about the digital revolution you've got into. But today I'm getting to hear it firsthand from you about. I had no clue about the Punjab digitization and all, but it's so good to know, sir, actually.
You know, apart from the fact that, of course, the team was there to digitize it, but our team in the High Court was very responsive, very creative, I would say so. Like one problem we had in Punjab was the certified copies were not available for months together. It was a very big problem. So digitization became easy, and we said that the certified copy will be issued without waiting for the physical file, because they will not issue a certified copy if the physical file is not there. So we made
Mm.
uh, it compulsory that all orders, even say adjourned to such a such date, will be digitally signed. So uh, it became easy. The copies were available. The superintendent of branch, she came to me that we still face difficulty,
Okay.
that on each copy there has to be one stamp of the court, and there is a
Okay.
stamp on the a rectangle stamp on the top of the page, which they
Mm.
require to be applied. That will also takes time. No, just creative. No, she
Mm.
thought that it's a mistake. It we can fast process the supply of the copy. So I
Mhm.
consulted my the agency who was digitizing it. He says there is nothing impossible. We'll find a solution. He came out with the solution. So he the company prepared a stamp, both last page and the front page, and the officer has to just initial it. And we made it, actually, even the costing of copy was sent on a message to the advocates that this much amount is payable by you or is deficient.
Mm. So, since we are talking about digitization, now a new era has become artificial intelligence, which is increasingly being used for legal research, document review, and predictive analytics. How do you see AI transforming legal practice in India over the next decade?
AI is a beneficial tool, but it is challenging also. Sometimes I have written one article yesterday on AI in court pleadings, whether I should use. I have used the word AI hallucinations
Okay.
because sometimes AI is in overdrive. Something is created which is not even there. There is a reported, again from the newspaper. Citations are there, but which is not
They don't exist.
don't exist. In
Yeah.
fact, in one of the judgments was attributed to a judge
Yeah.
who retired 5 years earlier. So,
I read that article too. Yes.
so that's A is good, but we can't be subservient to AI. The master should be the lawyers or the judges whatsoever. AI can be good tool, but we can't give it a status of uh, controlling authority. We can't
So,
wholly depend upon.
but do you
Like
think AI can contribute meaningfully to reducing judicial delays, or are there risks that legal professionals should be cautious about?
AI can be used to group the matters,
Okay.
like accident. In Punjab there is a large number of accident claim cases.
Okay.
So, possibly you can club it that if there is a death of a lady, death of a child, death of a man, what is the age, all these things can be collated and then can be made available to the court. But to say that it will write a judgment, no, I will not say.
Mm.
That is, human mind is still the creative mind. You can't depend upon the machine.
True, sir. Very true. Sir, coming back to a little of your background, actually. So breaking into legal profession can be incredibly daunting for someone without any family connections or network in the field. What practical strategy should a first generation student focus on during law school to build a self-sustaining practice?
No, the difficulty these days is everybody wants to be successful on day one.
Yes.
You know, if somebody has joined Supreme Court bar, he would like to compare himself with Mr. Mukul Rohtgi or Kapil Sibal or Abhishek Singhvi. They have put in a large number of years in
Yes.
working, learning the process. And you can't overnight become successful. Uh, when I joined profession, my grandfather was alive. I had gone to him to take my blessings uh, before I went to court for the first day. He gave me a wonderful message that holds good even today. He says, you must prepare the facts of your case very well. If the facts of the case are on your fingertips, you can counter the other lawyer because sometimes the lawyer can uh, over, I won't say intentionally, but by oversight, give a wrong fact. So, as if you know the facts of your case, you can correct it. That's the first thing. And other thing, second important thing is that even if you don't know law, that's all right. Law
Mhm.
one learns by experience, but the facts are within your knowledge. You must master it. So
Rightly said, sir.
I give you example. Three judges from Punjab, like CGI
Yeah.
Surekant. He's a self-made
Mm.
lawyer, judge, and then chief justice. He comes from the family of teachers, and
Okay.
at the age of 39, he was Advocate General, Haryana. And at the age of 42, he was the judge of the High Court. It's only sheer luck. Like I
Mm.
will give you the example of Justice Mercy. Again, nothing in with legal background, but with his sheer labor and dedication. Even some time back, Justice Rajesh Bindal, same way, first time lawyers. Justice
Well
Arun
said.
Palli, who has been recently elevated, is stand on a different footing. He has the same lineage as mine is. His father was a lawyer and a judge. His grandfather was a lawyer. So, but it really doesn't matter. You know,
Mm.
this is it's used as a I would say excuse to deter the young lawyers. Nothing. There are many young lawyers who are in profession who have no family background.
Mm.
As if you have a family background, you will get the first case.
Yes.
But the second case you will get, you have to earn it.
Oh.
The client will not come to you second time unless you have done reasonably good for him. So the successful, the background helps. I won't say that it doesn't help, but it helps only to get your first case. You
Right.
know, when I became a lawyer, my father was already a judge, and I thought that uh, the lawyers, he had the contacts everywhere. So I will get the cases. Not a single lawyer from his contacts ever briefed me. So I had to build my own network.
Mm. Right, sir. And today, do you believe that the entry of international law firms will create a greater opportunity for Indian lawyers, or will it increase competitive pressure on domestic practitioners? What safeguards should be implemented before the liberalization of legal services to ensure it benefits both clients and the Indian legal ecosystem?
No, the competition brings the best in you.
Hmm.
If we keep within the shell that we are very good, unless you have exposure of the better ones, how can you improve? There has to be yardstick to improve. We have no comparison. Comparison is with A, B, and C,
Yes, sir.
not beyond it.
Yes.
I remember in one case, a local commissioner was appointed to record evidence. The questions were framed by somebody in England about the CPC.
Okay.
The local commissioner was surprised the kind of questions which have come to her were unimaginable. Nobody ever thought the depth of CPC in that manner, which the lawyers in England have put labor. So competition will improve upon you. It's like before the liberalization in 1991, we were very happy in whatever we were doing,
Yes.
good, bad, indifferent, because there was no competition. And once liberalization happened, so we had to face the world, and
Yes.
we have, we have done remarkably well in that also. So competition brings best out of you.
Yes, sir. And I also read somewhere that, Indians do work under a lot of pressure and competition. They give the best when they're under competition. So probably this is a great opportunity for us.
Yes, it will be great opportunity. Some or the other, uh, some lawyers think that their monopoly will come to an end or something of that kind. But you will learn better. You will learn better the aspects of law. In arbitration field, there's raised objection that the foreign lawyers can't appear before an arbitrator.
Mm.
What's what's great about it? You know,
Mm.
what is the great objection about it?
True.
It's arbitration is not court proceedings.
Yes.
And international arbitration disputes are handled by best of the lawyers. What has happened? There were three arbitration proceedings in three different arbitral tribunals. I was not member of any of them. Next sitting, they fixed it in Singapore or London. At whose cost? You
Right.
know, the lawyer will not change, the parties will not change, only
Correct.
the losses of Indian lawyers.
Yes. Rightly said,
So
sir.
I think we should welcome competition, and competition will bring best out of us.
Right, sir. Sir, You were the chairperson of the India International Arbitration Center, and continue to play a significant role in the arbitration ecosystem. What, in your view, are the key factors that have made Singapore, London, and Dubai preferred arbitration hubs?
No, India is a huge country uh, as compared to Singapore or Dubai, or even
Yeah.
for that matter, London. Uh, and we have multiple institutions in India. Like Singapore has only one institute, Dubai has only one institute, and probably India has 44 institutes in India. So, which one is can be said to represent India? Uh, I thought probably because ours was the only statutory body, so we should take lead in having that. But
Mm.
then I consulted my friends in the field of arbitration. They says you never know which of the center will pull you or push you. You know, so there is competing interest. So
Okay.
I thought that if we do better, the market will take care,
Mm.
will obviously prefer. But ecosystem in India is very different. Uh, Litigation takes a lot of time. People have
Yeah.
strong reservation about the timeline and
Mm.
uh, the way the arbitration is conducted in India is not at par with any of the international jurisdictions.
Okay.
Uh, you know, in India, there is a lawyers who will do in the morning the courtroom work, and the evening they will do the arbitration work.
Mm.
And that's not the way anywhere else the people work. They are the lawyers who work exclusively on the arbitration field,
Okay.
uh, and they are available at any time. Because arbitration is taken in India as not the first preference by the
Right.
professionals. So generally they say, give us time after the court hours, Saturday, Sundays, when the court work is not there. That obviously has a constraint. But apart from
Mm.
that difficulty, in rest of these jurisdictions like London, Dubai, or anywhere, or Singapore, the arbitrator fixes the timeline, which is very strict. So
Mm.
if the pleadings have to be filed, say, uh, 28th of June, it has to be filed by 11:59 p.m. It can't be 12 p.m.
Mm.
You lose your right of filing your pleadings. So people follow those timelines. But in India, we are very relaxed about the pleadings part. Then the difficulty arises about the recording of evidence.
Mm.
Once the dates are fixed for recording of evidence, they are strictly adhered to. If 3 days are given to the claimant, you have to close your evidence within 3 days. It's for you to manage how to
Right.
complete your evidence within 3 days. But uh, I will not say anything about recording of evidence in India.
Sir, and which is why saying in that light, what you just said, I was going to ask that what lessons can India learn from institutes such as Singapore International Arbitration or the London or the Dubai International Arbitration Centers? And as you pointed out few things, what reforms are necessary for India to emerge as a preferred seat for international arbitration for global business?
The problem is you can change laws. You can
Mm.
make laws more efficient or whatever, but you can't change mindset by law.
Yes, sir.
We have to change mindset, and which can't be done unless we are committed to resolve that India should be hub of international arbitration. I used to speak at many events. Says if somebody says that appointment of chairman is good enough for resolving
Hmm.
India as a arbitration? No. I can be
Definitely.
catalyst of it, but it has to be effort of all. That effort of all is still a pipe dream.
Right, sir. Rightly said. So, sir, if you were interested in implementing one major reform in Indian justice delivery system tomorrow, what would it be and why? What is your vision of the ideal Indian court system in the year 2047 when India celebrates 100 years of independence?
No, we are continuing with the old system which were in existence in 1947. Same British legacy system. We wear the same uniform. We
Yes.
follow basically the same laws. Some cosmetic changes here and there, but substantially it is the same laws. How do we change? And amendments in CPC or in basically CPC to
Yes.
streamline court functioning has not been successful. Some or the other, they have not met the judicial scrutiny. So I don't know. It has to be complete revamp of the judicial system, but it's not now possible. Everything was possible soon after independence was there. People were
Right.
high on it. But now, after 75 years of
Yeah.
independence, the habits have percolated, have become very hardened. We are not open to change.
Yeah.
Like black gown or black coat is
Mm.
neither conducive for our weather nor for
Yeah.
it has served no purpose. In Punjab, we decided long back before I became a judge that in summer months people can dispense with need not wear gowns. At least one layer of uh, extra warmness can be reduced. But
Mm.
that's not true in many other courts. But we are not open to change. We want to continue with the same system. It's very difficult. It has to be complete revamping. Laws have to
Yeah.
be same, simpler. Laws has to be less laws, more effectiveness. Uh, it's a complete revamp. Like our judicial system, criminal justice system is manned by the same kind of a police.
Mm.
And unless we change the police, unless we change the mindset, unless we change criminal dispensing system, how do we improve our working? No, even for civil work, for government work, the center of authority is district magistrate or the collector, wherever it is,
Yeah.
whatever name you. So all actions are to be taken by him, and uh, he hardly finds time for anything because welfare schemes are to be maintained by him. The host of the activities are to be taken care of by him. How do we find time? One person
Right.
can't do it. Then we have the second in command. And second in
Mm.
command also has, again, the limited manpower. Uh, like I will give you example. In all time, there was one deputy commissioner and one SDM or something second to him. Now we have couple of them, 6 or 7 of them. But still the work, you
That's,
can't, with the time passage of time, the population has increased. Expectation of the people from the government has increased.
yeah.
How do you deal with that? You have the only way is to simplify the procedure.
Mm.
We can't do it uh, in the present day system. One system which was initiated was lateral entry in the
Okay.
higher administration.
Yes.
But it has also run into problem. You can't have a lateral entry until you have
Mm.
reservation of seats.
Yeah.
there are different problems at every level. So we have to live with it, I would say so.
Yes.
Not very happy situation, but how do you do that? Make best out of the lot, whatever is possible. System we have not changed. Instead of white Sahab, we have now become a brown Sahab. That's the only change.
That's good. That's rightly said. And so, lastly, looking back at your entire journey across various high courts and the Supreme Court, what is the single most vital legal principle or systematic reform you hope the legal community remembers you for championing? I, for no one, but what do you, according to you, is that one systematic reform that the legal community should remember you for championing?
It's very difficult to answer, but I would say that uh, single reform, it can't be reform, single change, I would say, in the personality of the judge. Do your job diligently and fast.
Yeah.
Uh, uh, I remember a long time back, one particular judge heard the orders on the bail for 2 hours. If on
Okay.
bail you have to hear two hours, then what else you will do in the day? Either you make up your mind, grant bail or refuse bail. You are not deciding any of the rights of the parties. Only question is, if you are so convinced that person is not guilty of anything or whatever may be their background, grant bail. Why hesitate?
Right. Thank you so much, sir, for sharing your insights and experience so openly. Your words of advice are going to inspire a lot of our viewers. And you've been incredibly kind and generous with your time and guidance here. We really appreciate it, and we wish you the very, very best, sir.
Thank you, Ritu. Thank you very much.